Manever I say ma PENDREAM TV. PENDREAM TV there osia dem yopo.
If we are going to be law abiding properly, when you finish voting, you should be able to go home. I hear Martin when he says you should be vigilant. Vigilance assumes that one, the other party is going to cheat. That's one. Mm-hmm. Two, it assumes that the Electoral Commission is incompetent. All right? And if we are going to be law-abiding, as in the other party is not going to cheat, which I don't think I'm going to put any money on, because I know the nature of politicians and human nature is like that. But if the Electoral Commission will be competent, it should be possible for you to vote and go home and for the results to be properly declared and be valid. And we have said over and over again that...
if, in a way.
Of course, if. We've said over and over again that, look, some of these problems, if you look at the Electoral Commission and the kind of resources they have, it doesn't make sense that we have these problems. And we've asked many times why we can't apply a bit more, you know, just even technology. For instance, you count at the polling station, okay, immediately you send that information. Your mobile phone can do that. And the Electoral Commission spends $100 million per election. What do they use it for? We've talked about the kind of equipment they buy and some of the things that they do. So I hear when people say it's one of the polling stations, you must be vigilant. I say that is what leads to violence. We must get to the point. And I may be sounding utopian or whatever it is, but I'm telling you, that's what we have to work towards. We should get to the point where we are using our national ID cards to vote. Why? Because that will tell you whether you are 18 years or not. You put it in the machine, it can tell you. Because when that thing was done, it was not done for election purposes, for you to go and change your age. And if you change your age, it will affect you in other places. It's called agnostic systems. Okay. We have the technology today to do that. Just procuring machines, you go there, it will say, you are so and so, you are from here, it can let you vote. And the collation can be done electronically and sent electronically from the polling station. There are things that we can do to make it less necessary for political party operatives to mount vigilance by themselves. Because there are two opposing parties. True. This person mounts vigilance, the other person mounts vigilance. What you are calling somebody's vigilance is somebody's aggression. And we have seen in this name of vigilance, people firing guns. We have seen people stealing ballot boxes in the name of vigilance. It's lawlessness clothed in English. We should get to the point where our Electoral Commission is competent enough. How big is Ghana? And how large are these polling stations? Why is it that simple things beat us and we end up spending so much money and going through so much stress? Okay? So if you ask me, we should move to the point where vigilance becomes increasingly unnecessary. So I still insist, elections are not won at the polling station. Voting happens at the polling station. The process must be properly gone through. The EC officials are officials of law. They work under law. Even the person who makes the declaration matters. All right? True. And they have to do things properly. We've gone through the election.
We saw it even in Tema Central.
Yes.
Also, who made the declaration and whether the person was competent enough in law.
Yes, in law. And that is fundamental. It matters. We've gone through election petitions. We've seen pink sheets and how they were treated. All kinds of things happen. I myself, with my senior Akoto Ampao, okay, had to go to court to force the Electoral Commission to treat pink sheets according to law. Otherwise, we'll still be in trouble. All right? It shouldn't be necessary. It shouldn't be necessary. And the pressure should be on the Electoral Commission because they lack no resource. And this is not a difficult business that it defies doing, okay? Even with reasonable facilities and, you know, capability. So I don't see why we have to have these fights and people come into parliament and then later on they spend a year in court. Look, in the case of Rebecca Adote some years back, by the time the decision was made, the whole period was over.
Was over, yes.
Okay, and so you deny the people their representation for all the 4 years. We just went through SAL. What is the problem with SAL? The Electoral Commission. Okay, so see, we have put so much in the hands of that institution and clearly they are not up to scratch. We should focus on that and then we avoid these things.
The truth, which is uncontestable from Kofi's analysis, sorry, Mr. Bentil's analysis, is what we are seeing playing out right now. Dr. Joshua Zaato, in the Kwandai constituency.
Thank you. Both gentlemen are right. Elections are won at the polling station. It's more of a political statement and not a legal principle. It's the idea, it's a political statement, simple saying that, look, don't, like, It's not even a utopian idea that, look, is the results people vote at the polling stations. That is their first contact with the voting. And as I said, there's somebody who is in the market, votes and goes back to his market. He goes back to his farm. He goes back to his normal life. So since it's the first entry of the voting process, it then means that is where the elections, that is where it really matters as to who does that. So as a political principle, it is then your duty to make sure that, one, elections are won at the polls also means that it's your duty to make sure your people show up to vote. It's your duty to make sure people show up not only to vote, but to also vote well. It's your duty to make sure that your people go out there in their good numbers and they are more than other people. And so, as a political statement, it matters because if your people don't show up to vote, if your people don't show up to vote well, if your people don't show up and do the right thing, then no matter what happens, you're going to lose the elections at the polling stations. So the polling station then becomes the rallying point and the main of the elections.
Yes.
Because that is where you vote. There's something that used to happen around 1992, 96. Some of us were kids are going there. It was the phenomenon of the snatching of ballot boxes. Those times, that was where the whole idea of just macho men came inside. When we used to move ballot boxes to places to go and count. People were snatching ballots. So the emphasis then was on ballot boxes. That is why you saw that from 92 to 96, in other words, this country, through IPAC and others, we invested to improve the ballot box processes. So the whole idea of making them transparent and the whole process of counting them at the center was to try to demystify this thing about the ballot box and also to discourage the snatching of ballot boxes. So, I mean, if the results are already counted and declared, they use snatching the ballot boxes of no consequence. That was the whole idea, to disincentivize, again, hooligans from snatching ballot boxes. That was the idea, the central idea there.
I see.
Now, my point is that the emphasis has now, so over the years, we've done a lot as a country at the polling stations. What we have so far not done, or what the new trend that is now coming is at the coalition centers. People have now realized that if you snatch a ballot box, it's useless to snatch a ballot box because the other candidate has it. And usually, if you realize, by the time you are going to the coalition centers, losing candidates no, winning candidates no. Everybody has, and you can use very rudimentary, like he's saying, technology to collate your results. So that by the time that all the results are coming, sometimes if you live in a place like Sisala East, which is just by distance, by how big it is, one of the largest constituencies in the country. By the time somebody leaves Santijan and is carrying a ballot box to Tumu, it depends upon it may cost 30 minutes, 1 hour to come. By that time, the coalition, they've already got the results. So what people have now started to do to give the system is to attack coalition centers. Coalition centers have now become the most vulnerable link in our electoral processes. And we are here today because of events like that. My point is that unless or until, and the coalition centers, yes, it has a technology, but there's security issues. We should be able to have coalition centers that if we say these people are not supposed to be there, they shouldn't be there. If we say that these people have no right to be there, they shouldn't be there. We should do that. But quickly, I wanted to go back to the map on some.
Because you stayed a bit on this matter of whether elections are won or lost at the polling station. Mr. Kofi Bentil has done justice to that particular issue, and this is where I welcome Nelson Roxon Dafeamekpor, is the majority chief whip in this 9th Parliament, in the Member of Parliament for the South Dyke constituency. He's a private legal practitioner in good standing. Good morning. Welcome.
Thank you. And good morning to my senior.
Thank you.
And my junior.
Good.
And my friend. In fact, my genius. And my friend, Dr. Zaato.
Oh no, is it the fertilizer to Utawa? You know,
the fertilizer I'm told that fertilizers have been supplied. You haven't gone to see your DC. Are you fighting your DC?
No. Oh, he said
So
good point.
so
So the free fertilizer is there.
That's my
Thank you, General.
My DC, my MC is Cadet. We call him Cadet. Cadet and Niane. What's my fertilizer? I'm just telling you
I left here that day. I called Eric Opoko. I said, Minister, you heard Dr. Zaato. Zaato says, also, no. Zaato has refused to go and see. Zaato is dealing with his party people. He's not dealing with the MC.
Okay, so Cadet, I'm coming to you. I'm coming to the MC for my letter.
For this, let me also acknowledge the presence of, he says,
It's
The
It's
MPP
a
is so strong
4-3
on the
as we
ground.
speak. It's a 4-3 as we speak. And we seek to make it a 5-3.
You want to win.
If you recall the events of the morning of 7th January 2025, I was one of the people who told Senior Nyindam that you are on secondment, you are on probation. In fact, I used the phrase, Senior Nyindam, you are on probation, because we raised the issue that we were contesting the results in court. You know, himself and my late brother Fuakwetia, you know, and Skumi, and Ernest and I, no, we are young, we are vibrant, we jive. But we wanted him out because of the pepper they showed us in Jachikwese. But they told us that they were willing to face the consequences. So they should be sworn in. If you recall, we took issues with Jetro. Because Jetro was then, the clerk to parliament was then standing orders. He would swear in the MPs. Then the MPs will now have the locals to now vote for a speaker. Because we didn't have a speaker at the time. So we raised the issues. And Nyindam told me, I'm senior to you in this house. Whatever you say, me, I'm strong to face the consequences. I said, for now you are on probation. And we laughed about it. Then we sat quietly and went about our court matters. We were not fanciful, we were very methodical. So after about 11 months, the court made a pronouncement, not in our favor. We were looking for a decision in our favor. It didn't happen. It was a neutral decision based on issue 1 that we set for determination. If you look at the issues set for determination, our issue 1 was whether or not the infractions in the 41 constituencies were such that they affected the outcome of the elections in the 152 polling stations. And the judge agreed that, yes, they were so material that it contaminated the sanctity of the outcome. So, Electoral Commission had been directed to go, and this is the order of the court, properly drawn out. It says, upon hearing both petitioner and respondent's lawyers, blah, 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 it is hereby ordered that the petition of petitioner is upheld. And this court orders a rerun of the Kmandai constituency parliamentary election in 30 days. Second respondent to comply with the order.
That is the Electoral Commission.
That's the Electoral Commission. And you know, being a diligent lawyers, we took steps to get the order drawn out and serve on Parliament. Originally, Parliament was part of the suit. Parliament and the district director of the Electoral Commission, but later they got non-suited. And so we proceeded against Nyindam himself as first respondent, and then the Electoral Commission as the second respondent. But ex abundante cautela. So we serve Parliament.
So what does that mean? What you just said?
For want of abundance of caution.
You have to communicate in plain language.
Oh,
it's a plain language movement
people,
that is going on.
Sometimes you must communicate to the technical people to like.
But you are communicating
like Kofi Bentil,
to the masses,
communicate to them.
Not the learned colleagues of yours.
You are now in the law, so you need to. You haven't told the people that you are now a student in the law. So you need to be using the jargon so that they know. People appreciate you when you are in the law. Yes.
Please go ahead. Please go ahead.
Zaato, you yourself, you must go to law school.
I would.
You must. Otherwise, you are not learning.
Stay on course. Stay on course. Please go.
No, that's by the by. So we took precaution to serve Parliament that these were the events happening in one of the high courts, and the outcome is that a seat in Parliament has fallen, and he got Speaker to pronounce. On the 25th, when I raised the matter, 25th, 27th, when they decided that Nyindam should make a statement, should comment on the principles of the budget. So I said, no. Nyindam no longer has locus.
Right.
We've tolerated him for 10 plus months. But as we speak, It's been denounced by a high court of this republic, and that is the High Court Tamale Commercial Division. That the ex nihilo fits, because you see, you can't put something on that and expect it to stand. The pronouncement that brought him to Parliament, which I questioned from day one, has now been determined. So he no longer has the locus. He has no locus standi on the floor. They wanted to chew my head off. But eventually the Speaker said yes. Per the terms of the order, it meant that Article 97 has been sprung back to life. There's a vacancy. But you to avert your mind to CI 19, Court of Appeal rules, I believe 20 or so as amended by CI, I think 119 2020, where it's been amended that there's automatic 7-day stay. So the automaticity of the stay is such that you can't ask Nyinam to leave the floor today. But after expiration of 7 days, which expires on the 1st of December, he no longer would. Because Speaker was very clear. The Speaker threw in a punch and said, if he files a further process, that may mean that Parliament's hands may be stayed. He uses the word phrase, may.
Yes.
Now, the may means if those are brought to his attention, then they may have to come to a decision to further stay their hands. But the may means that you have to persuade him.
I see.
Yes, so those persuasions didn't happen. So
What do you mean by you have to persuade
if the man says, if the man files further processes, but it is right, and Bentil is here, very learned in the law, learned before, so his study of the law was reading of the law was an icing on the cake, because he's been reading our constitution long before he went back to law school too, for shege reasons. As for him, he studied law for shege reasons.
I see.
Yes, that's for you. You
Just
see,
throwing punches.
left, right, center. Punches. As for Zaato, today I'll kill you.
Thank you.
You know, so Kofi knows that it's right. Look, 5 years ago, I made the similar arguments on behalf of Jachi Kwesi. But not on the floor, but in the foyer that we have filed a notice, we filed a stay. They say I was espousing bad law. And this came from Chei, the majority leader, who isn't a lawyer. They briefed him, they prepared a brief for him. Chei finished me on the floor and said, you lawyer of some long standing, you are espousing this law. I have been properly advised that your law is bad. I know he was the majority leader at the time. He finished me. So Kwesi never got to stay in Parliament with an interim order, not an order determined by the court on the merits of the case. So I came to the foyer and said, well, I was hoping that having filed a notice of appeal and a stay application notice for stay, it was sufficient. Oh, no. You say my law was weak. I was espousing law weak, jurisprudence, blah, 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 blah. So Jachi Kwesi, he lost his standing in Parliament. He lost his salary. He lost his entry to his office. Anytime Jachi Kwesi came to Parliament, he had to come to me or went to the majority whip at the time, the Honorable Abuja. So now I want to espouse the position of the majority, now minority. They say, hey, no. The law has changed. I say, who changed the law? Because it's a mere filing of an application for stay of execution does not amount to a stay. This is the authority in Ghana Hotels Association versus Pig Plus.
A mere filing of the application.
A mere filing
does not amount to a stay.
And you know, in the 1997 Court of Appeal route, I think CI 19, there's some leeway. But they came to tighten it with an amendment in 2020. Zaato and his party. Not me, Zaato and his party. They say a filing of a notice that is a notice of an appeal, all right, cannot operate as, shall not, in fact, they use the phrase, shall not. And I'll put those Court of Appeal rules. Shall not.
No lawyer contests that.
Yes.
Good. So when my brother said that, when they came to Parliament on Tuesday and stampeded the processes and said, because they have filed a notice of appeal and filed an application or notice for stay of execution, none of that had any force of law. The only order that has a force of law is the order emanating from the Court of Appeal. And then when they finish exhausting all the processes they were entitled to file at the Court of First Instance, which is the High Court, and then filing the notice of appeal at the High Court, but of course at the Court of Appeal, they now proceeded to the Supreme Court with certiorari. So they are now forum shopping. Because if you believe in the merits of your case, you won't do this. You won't say that you are going on appeal against a decision of the High Court, and then you will be seeking before the Supreme Court an application to have that decision struck down.
That appeal is going to be held on the 18th.
Yeah.
But
No.
This is certiorari you're talking about.
No, that's certiorari. So it's not an appeal.
These are the reliefs.
No.
The 18th is the stay of execution.
Certiorari is a judicial review application.
This is it. This is what they are seeking.
Yes. So the one before the Supreme Court is markedly different from the appellate processes that they are entitled to and have triggered. So let me give you the genesis. So they have filed 2 notices of appeal.
Okay.
2 applications or notice for stay of execution filed by lawyer San, the original lawyer, and with a change of notice of solicitor filed by Gary de Maku. So it's been adjourned to the 18th. But before that could be heard, they are before the Supreme Court for a certiorari. Now, before this could be determined, they are in Parliament singing Aluta songs. Today, the MPP is singing revolutionary songs. Zaato, are you aware?
I see.
That today you are taking the path of the PNDC that you vilified.
Well, their stance is this, and this is what he referenced. I'm going to show you what happened in Parliament within the week. That chaos that disrupted the business of the House.
No, but let me finish.
Because I'll let you finish. I'll come to you because you see, this has attracted the condemnation of Mr. Bentil and all the others here. Let's take it.
No. Okanse, let me finish.
I'll let you finish.
Honourable members, Right Honourable Speaker should take the chair. Defense and Interior. Just the motion number 10 to read it. I so move. Thank you. As if it was wet. Mr. Speaker, I urge the House to
Science and Technology on the allocation of the sum of 1,349,588,593 for the services of the Ministry of Environment, Science and Technology for the year ending 31st December 2036. In doing so, Mr. Speaker,
by the gentlemen. Gentlemen. No, I'm talking about what's happened. Gentlemen. Okay.
Yeah, that was
okay.
Can we see that video?
Me and by Sam George and Susu.
I am referencing what happened this week, right? With this, and that's what you, Kofi Bentil, you condemned over the week about how chaotic Parliament is becoming. I mean, just a brief one on that, and then I'll just.
So
we got into the legal matters already. Yes.
If you look across the world,
yes, you finish. You finish.
It's just this. If you bring Kofi now,
you'll finish.
Kofi will take 30 minutes. You'll finish. To do a 5 minutes argument.
You'll finish.
We are talking about the conduct in Parliament. Okay. Look, sometimes I think when you are in
Parliament, that's why I brought the code of conduct.
I'm speaking from the point of view of a citizen.
Okay.
When you are in Parliament, sometimes I think, or it seems to me that you forget that you have TV cameras on you. No, wait. Let me make my point. That's one.
Yes.
Now, and then let me say, generally speaking, I've watched footage from Japanese parliament and other parliaments in the world. People were throwing shoes. So it seems that where you have people debating, things can easily degenerate.
Testosterone.
Then, speaking from the point of view of a citizen, look, Ghana has a very, very, very good reputation in West Africa and across the world. When these things happen, we get calls from around the world. What is happening? You know, and for Roxanne and Co, maybe they are having fun. I mean, you look at some of the people there, they seem to have been smiling through it all. But trust me, it is traumatic for some people. All right? And then the point I want to make is, where you have debates and it's this spirited, and you have situations where, like I said, in places like Japan and other places, you see people throw shoes and throw punches. When you get into situations like this, you put yourself in danger of it degenerating very quickly. Somebody could have hit somebody in this situation. This thing could have gone in all kinds of places, and then you'd have dissolved or devolved or just, degenerated into a fisticuff. And please, you represent us. And I find it sometimes difficult, almost offensive, that I have to explain for what Roxanne is doing in Parliament and for what people are, doing there. You represent us. So keep it in mind. Roxanne, keep it in mind. When you are in Parliament, there are TV cameras on you. What you do there does not remain there. Okay? People start calling and what is going on in Ghana? And you'll be surprised
like
that
a stadium,
we have friends. Let me finish. I have friends in the diaspora who listen to Ghana news more than the news of the countries they live in.
Sure.
And they are sometimes things I don't know about. They will call and they'll be telling you this because they listen to every radio station and then they watch YouTube. So Roxanne, please, you and your colleagues, keep in mind that you represent all of us. And with that in mind, be a bit circumspect in the kind of scenarios and spectacles that you create.
Were matters that we in the NDC methodically pursued judicially.
Okay.
We are not making those demands whimsically. These are based on proving judicially established decisions. We made the point that yes, by all means, file processes, by all means, hold your press conferences. But even if you come to the floor and you raise concerns, don't be disruptive of parliamentary proceedings. So we can say, what did we do? We got the order of the court served on the clerk to Parliament, and then invariably the Speaker. When you serve an order of the clock of the court as ordered on the Speaker, there ought to be consequences. I saw Professor Azar wrote that Parliament needed to do nothing. I disagree with him.
Well, we have a portion of that.
Yes.
Said.
I disagree with him because you see, Parliament initially was a party, the clerk, but on the 15th of May 2025, the court misjoined Parliament and the district director of the EC and maintain Nyindam as well as the EC as the respondents. So when the order was issued and directed that the second respondent to take action, Parliament ought to be served. Service of an order of the court is to put you on notice. Once the notice comes, so Speaker was clear when he said, by the terms of the order, invariably Article 97 has been sprung to life. There's a vacancy, but I cannot pronounce it now. So Majority Chief Whip, your demand that the member be pronounced a persona non grata was premature because of the Court of Appeal rules. So after a flushing of time, 1st December, Nyindam was no longer eligible to appear in Parliament. Now, once I got the order served on Parliament, I got the order served on the EC. Parliament needed to inform the EC that there's a vacancy.
Even though one of the lawyers.
Oh, but this matter, you have to see. You have to go back to December 2024, and early days of January 2025 to understand. I'll be central to all the disputed matters.
Yes, we could see on TV.
Because the chairman personally called me and said, look, we need you to handle these matters and coordinate them. So Tema Central, Techiman South, Obuasi East, Suhum, Nsawam, Okainkwe Central, Okainkwe Central, Ablekuma North, then there's that's Akwitia, and then Pandai, this one, and a couple in the Ashanti region. We went to court in all these matters. And the 5, that is the notorious 5, Tema Central, Ablekuma North, Okainkwe Central, Domi Kwabinya, and another one that were put together by our Director of Legal for a composite action. But apart from that, we went to court individually in respect of and then Techiman South. So it was those 5 that were put together and filed court of, if you followed, we went to the High Court and then they petitioned to the Supreme Court. Supreme Court decided that the court must come back and reorder, if you recall. But apart from that, 4 others went to court, including this one. You see, Suhum is also pending. Suhum is before the Kofi High Court.
I see.
So we haven't been indolent. We've been very methodical. We don't like talking in the media. But we've been in court all this while. So once this decision comes, look, if anybody says Nyindam will be disadvantaged, the greater damage or harm will be borne by Nyindam. What about us? The NDC, we had a seat. We had a city member of parliament, and the decision came and disfavored us. We didn't take machetes to parliament. We didn't take cudgels. So hold on. We went to court and allowed Nyindam, but we cautioned him that we are in court. The day that the court will decide, he should be ready to face the consequences. He told us that he was ready, and now the pronouncement is here. Not in our favor, not in anybody's favor. There's a rerun. Then you say that even though there's a decision against me, I have filed a notice of appeal, which is a mere paper, because it can be withdrawn tomorrow. I have filed an application or notice for stay, which is also a mere process. It can be withdrawn tomorrow. The order of the court, which is subsisting, and the new Court of Appeal rule says that a filing of a notice of appeal on an application for stay of execution does not operate as a stay until there is an order of the court setting aside or staying the order of that court. I didn't bring this amendment. It was brought by Zaato and his government.
I see.
To amend the Court of Appeal rules. So the new Court of Appeal rules says that until there's a substantive order of the court of first instance or of the Court of Appeal, the order of the court must be obeyed. You don't want to obey that. But you want me to allow you that because you filed a process. Me as an NDC, I should be disadvantaged. We won't do that.
I see.
Because when the equities are equal, the first in time must prevail. And I have the first equity in this matter.
You made different arguments in the Kofi situation.
No, I was told that I was espousing a bad law.
Do you still believe those points you made?
No, I don't believe them.
You've abandoned them.
Why?
If it happens again, would you want this treatment to be meted out to you?
Which treatment?
What you are meting out right now to
I'm not meeting out.
No, I'm talking about your side. So, look, what I'm looking for.
Hold on, Kofi.
Okay, gentlemen.
Kofi.
So there's this.
Kofi,
this
listen.
is what.
Kofi, one of the government. Hold
Yes,
on.
round
One
up,
of the
round up for
government
me.
of the secretarial application is this. The EC actually issued several gazette notices between the 24th and the 6th of 24th December 2024 and 6th of January 2025. There were a lot of seats that we tangled over. After the tango, before the swearing of the 9th Parliament, the EC now issued this. So when the Gazette notification for 6th of January now contained all the seats except Ablekumanov at the time, this was what the EC brought to Speaker. And the clerk actually pronounced on this and proceeded to swear us in. And this contained Yindam at the time. So it was not the 24th December Gazette notification. So when somebody says they are in court because there was an initial Gazette notification, it didn't contain Tama Central. It didn't contain Ablekuma Central. It didn't contain Domiko Abenya. It didn't contain Techiman South. It didn't contain Suhum. It didn't contain Saoma Dredri. It didn't contain all those contentious seats where ballot papers were being moved from regions and declared at Etsano. So this was what the EC eventually relied on. That was why we had to refile the petition based on the issuance of this on the 25th.
Okay.
So these matters must be properly set.
You see,
This is the Monday since January. So the ticking of time began from 6th January upon the Gazette notification. It is after this that anybody who got aggrieved in respect of any of the decisions in the parliamentary elections could now proceed to court.
now the question Kofi was asking is, should this become a standard? If I get it right, should this become a standard for such happenings or future petitions?
Standard as in
if you are declared by a court of first instance not to have been properly elected, you are out of parliament, even if you file an appeal. You and I know.
Let me respond to you. In Jachi Kwesi, it was also a dispute over a parliamentary election. Jachi's matter was not determined on its merits. Our brothers, the NPP, they brought an injunctive order to say that before you hear the matter on its merits, injunct the man. The court heard application. For the first time, they departed from the beaten path and said that a constitutional office holder could not be injuncted from performing his until a substantive court says so, or a court order says otherwise. They departed and said Jachi Kwesi per an intermediary order of the court. They say he could not hold himself as an MP. So invariably his salary was stopped. District Assembly's common fund was stopped. Jachi Kwesi couldn't access his office. Interim court order. Before the matter could be heard on its merit, the court says you cannot hold yourself as an MP. We allow. No. Let me.
You are digressing.
No, I'm not
it's
digressing.
It's a very simple matter.
I am just opposing this with a similar contestation of an election of a member of parliament. His was based on nationality. That's the eligibility criteria.
Okay.
This one was based on. No, this one will go. Kofi, let me finish. This one was based on eligibility of declaration, of the sanctity of declaration of results, or the sanctity of the outcome. His was based on eligibility of competition. They say he was not eligible to contest.
Okay.
So, but a court, and we observed it. We say, oh, we have filed notice. Look, when Jachi Kwesi, when the injunctive decision was given, and eventually when the decision of the court, we couldn't even file a notice of appeal.
So
because the court registry was not working.
So
I want to say that my colleague was removed from parliament based on an interim court order. This one is a final court order, even though it's been appealed. So
I see. So that's why the question is that
people who
if there's
suffered
an
the
appeal
greater
in
harm,
place,
the group, the political group, the NDC, will suffer the greater harm in Jachi Kwesi than the NPP is suffering in Yindam. Jachi Kwesi based on interim order, in Yindam based on a final court order.
Right.
So who suffered the greater injustice?
Okay. And
So I beg you,
Bentil,
very important.
Yeah.
These things will continue. That's one. In every religion, there is what is called a golden rule. You do unto others what you want to be done to you. Now, you've said a lot of things, but the gravamen of the matter is this. When a court makes a pronouncement, circuit court or high court or whatever, an initial pronouncement over the eligibility of a parliamentarian.
They are not lawsuits.
I'm coming. I'm just making a principal position. Should we say that once that initial decision is made, the person vacates parliament? Or we should continue with the principle all of us know as lawyers that until a matter is finally adjudicated, it is not complete.
Okay.
To that, no, I'm coming.
Okay.
And when I say that, I mean all the way to the Supreme Court or until the person abandons it. It's a very simple thing, and Alfred, you can stay on this, let them answer for me.
Okay.
So, should we say that we will not listen to any appeal after a first decision is made? What it means, therefore, is this. If the High Court says you are no longer a parliamentarian, you leave Parliament. You can choose to appeal. Now, the EC can choose to do an election, and then you may lose the election. But technically, you can win the appeal. Now, if you win the appeal, what happens? Okay, so me, I'm saying, look, what does Roxanne want to be the standard in Parliament? Because we've gone through Jachi Kwesi, we've gone through even some previous situations. Now we have come here. In Jachi Kwesi, you said left. In this one, you're saying right. It seems to me that if it's on you, you make a different argument.
No.
If it's on somebody, so what should be the standard? If we cannot agree here, it will go into the record.
Okay, so 2 minutes.
So,
In
if you
Jachi
permit me, because this statement...
in 2 minutes.
No, you answer, because this particular question is also one that Professor Stephen Kokosari, you referenced. So this is what he posted, and we're going to put this on the screen. He said, under Article 112, and he's watching, and I say good morning to you, Professor Stephen Kokosari. Thank you very much for bringing my notice to this. So good morning, Professor Kokosari. It says, under Article 1125, and Abdullah is going to scroll it for me right now. Article 1125, it says, the clerk of parliament must notify the electoral commission within 7 days of becoming aware that a vacancy has occurred. The key constitutional question is, therefore, when does a vacancy legally occur if the validity of the seat is still being litigated under Article 99? 1. Article 99 places the determination of membership in the courts. 99.1 states that the High Court has exclusive jurisdiction to determine whether an MP was validly elected or the seat has become vacant. The clerk cannot treat a seat as vacant until the body constitutionally empowered to decide, that is the High Court, has made that determination. And he says that because Article 99 assigns the determination to the courts, a vacancy cannot be said to have been occurred where the High Court has not yet ruled, or the High Court has ruled but the matter is under appeal. And he says that once a valid vacancy is established, clerk must notify, and it goes on. It says when a conclusion, and let me just conclude on this so that Lord Dafeamekpor, you respond to the specific. It says when a seat's validity of vacancy is still being contested in the High Court or on appeal under Article 99, the clerk of parliament must not notify the Electoral Commission. A notification is constitutionally required only after a judicial determination of the vacancy. That's the argument Professor Stephen Kokosari made, and that's also what Lawyer Kofi Bentil referenced. Lawyer Dafeamekpor,
Okay,
please.
so let me anchor my argument first on this. If you read Rule 27 of CI 19, an appeal shall not operate as a stay of execution or proceedings under the judgment or decision appealed against, except where the court below or the court otherwise orders. A, in the case of the court below, upon application made orally or by motion or notice to it. And B, in the case of the court, which is the court of appeal, upon application made to it by motion or notice, and except as provided in this rule, no intermediate act or proceedings shall be invalidated. Listen carefully.
Yes.
No intermediate act or proceedings shall be invalidated. And 2, when an application is pending for determination under sub-rule 1 of this rule, any proceedings for execution of the judgment or decision to which the application relates shall be stayed. All right? This is the 1997 rule. Now, listen to the amendment. Listen to the amendment.
And it's important that we go through this exercise.
Yes.
For viewers to just bear with me.
Now, Rule 27 of CI 19. So let me say, Court of Appeal Amendment Rules 2020. That's CI 132, 2020. In exercise of the power conferred on the Rules of Court Committee by Clause 2 of Article 157 of the Constitution, these rules are made this first day of October 2020. So, Rule 1, Rule 27 of CI 19 is amended. 1. The Court of Appeal Rules 1997 CI 19 referred to in this enactment as the principal enactment is amended in Rule 27 by A. The substitution for Rule 1 of 1. An appeal shall not operate. They introduced this phrase. An appeal shall not operate. That's a notice of an appeal. Shall not operate as a stay of execution under the judgment or decision appealed against, unless the court otherwise orders on an application made in the court by motion or notice. B. The insertion after Rule 1 of, that is in the old rules.
Right.
A, that's 1A. Unless otherwise provided in this rule, an intermediate act or any other proceeding subsequent to an application under sub-rule 1 shall not be invalidated. So you cannot fault the clerk to Parliament communication to
the Electoral
EC.
Commission.
You can't fault it.
What should
C.
be done?
The substitution for Rule 3 of, that is 3, there shall be a stay of execution of the judgment or decision appealed against for a period of 7 days, immediately following the giving of notice of the judgment or decision. So this is the amendment. So basically, where you have filed a notice of appeal and apply for notice, application or notice for stay of execution, they have no value in law, judicially speaking, unless the court itself or the court of first instance makes an order staying its own order.
Okay.
So I didn't bring this amendment. This is an enhancement of the 1997 position.
I see.
So
does that answer the question?
It answers.
So
if Kofi is, so all of us must be guided. When I was espousing that, as practitioners, when I file a notice of appeal and followed it consequentially with an application or notice for stay, all of us ought to stay our hands. But they brought this amendment in 2020 to say that no, that is no longer the law.
I see.
It can be disregarded, and no intermediary action taken can be faulted, can be invalidated.
Interesting. And I'm going to be coming back to you a bit more. Justice Abdullahi, you had indicated that this release by the Electoral Commission, how
the Supreme Court says,
Yes.
So the Supreme Court says in Ghana Hotels Limited,
Yes,
versus Peak Plus,
yes,
the Supreme Court says that a mere filing of an application or notice for stay of execution cannot operate as a stay.
Okay.
At all.
All right.
So stay anything.
Right.
Otherwise, people will file a stay of execution and go to bed.
Thank you.
Well, in practice, that's what we all do anyway.
So this matter,
in practice, that's what we all do.
Practice,
we all do that in practice.
Yes. And the court.
In fact, Martin and I have had a lot of battle on this
now
one.
It is
both at the Supreme Court and
so
at the
when
Court
you
of
file an
Appeal.
application, you must be
for more than 10 years. Martin and I have been fighting on this.
What I did, I recalled the litigation. What I did, when I applied for an application for or notice for stay, I actually made a specific request for hearing within 3 days.
Yes.
Expeditious hearing.
As a matter of fact, now they give you barely a week.
Good.
Just so you don't go and sleep.
Good. We started
just so you don't go and sleep.
Thank you.
So
Yes.
for you to save your clients, you
there's
must ensure that the court hears you timelessly.
So there's some answer to that question you
Yes.
asked. So let's move on.
So-
don't invite him in.
So when you have
I never invited him. I never invited
so
him.
when you have the
I never invited him.
Hold on.
me, my boss taught me,
automatic.
taught to me that when you have
Automatic.
he says that when you have the 7-day automatic period,
Yes.
you file your application almost
Make sure you do-
immediately
yeah.
and apply to the registrar that this matter must be heard like.
Thank you very much.
Like within 5 days.
You've made your point.
So when you are heard
Now-
of merits and you are granted, by the lapse of the 7 days, you have a substantive order staying in the
Thank you
hands
very
of
much.
the court.
Right. Now, but
Yes.
unfortunately,
After the lapse of the 7 days, it will kick in.
Okay.
So it's all
unfortunately, right? As I was saying, the Electoral Commission finds himself in this whole quagmire where he has, she in this particular case, have very little room to operate.
No.
Let me finish. You let me finish.
No, this cannot go in.
Let me. Okay.
This
Wait.
cannot go
No,
in.
allow him. It's my time. Yes.
You want to allow him. Let it be on record.
The order,
Yes. Okay.
the order, in fact, paragraph 2 of the order says,
Yes.
it is hereby ordered that the petition of the petitioner is upheld. And this court orders a rerun of the Mandai constituency parliamentary election in 30 days. Second respondent to comply with the order. So after 7 days automatic stay, you must comply. Do you know what we did? We cited them in contempt.
I see.
That's what, because after the 7 days, if you don't issue the notice for rerun, you are in contempt of the court.
Thank you very much.
So,
I think you've
so
answered
the
the
letter from Parliament is actually of no consequence to Electoral Commission taking an action. But they pretended that they were rather acting because the Parliament has communicated. Because they are a party.
All right. Thank you very
When
much.
you are a party,
You
the
are
law is that
bound
you
by
don't
it.
even need to be served with the order before you
Just
comply.
like-
As a matter of fact, no, that.
Why are we here today? How did we arrive at Pandai? And then the question we have to ask is, if we are to blame somebody, are we blaming Parliament? Are we blaming the judiciary? Or are we blaming the ECA elections that happened at the forefront? I think, that should be. One of the most important things we are forgetting is that there's a reason why Pandai happened. And that happened because of violence. Violence at the coalition center. That is why Pandai came up. If on the night of the vote, if on the evening of the vote, we had gone inside and they had counted everything and everything was boring, and we left there and we went back, we wouldn't be here where we are today. We are here today because violence begets what? Violence. You see, the so-called violence you saw in Parliament, it started in Pandai. It started when thugs and hooligans attacked the coalition center. There's a reason why the coalition center was moved from Pandai to the Tamale High Court. That was a violence act. It was violence. Violence moved it there. And so that's what I was saying. Parliament is real. Parliament is not a kind of physics or chemistry lab where you can hold all conditions perfect.
Constant.
You then saw that same violence permeated, that same violence made its way into the Chamber of Parliament. And it was that same violence that motivated my brother Sticker to win that day. Okay, that's a lighter note. The bigger point is that, look, if we don't want to have more of those kind of things happening, then we need to also be able to say that let's go back to the rules. The rules is this. Violence, the violence that happened. I saw some of there are a lot of videos. The videos I saw, because listen, now today you said even if it was motivated by just a question, somebody triggered it. They're triggering it. Why Ghana Police Service, the men and women who went in the NDC pickup to that place and caused them, where are they?
No.
That's what I saw.
Wait.
I'm saying I won't wait. When you're talking, I didn't wait. No. You will allow.
Okay.
When I was, I'm making the point. I am making that point. Dafeamekpor, you will not stop me. When you went there, I saw people in the NDC pickup that went and disrupted this thing. Where are those people? The men and women who went and destroyed that thing, and we saw the papers flying this. Good. If we don't go down to the heart of that violence, this is what is going to happen. Our coalition centers are now becoming the weakest point in our electoral system. Our coalition centers have allowed people, today look, people can easily game the electoral system. You can do that. What did you do? Every coalition center, you have a smartphone, you can start collating your results from every polling station. If you take Sisala East, for example, far end to the end of Upper East is Santijang and these places, then you can go all the way. The distance is long. So by the time they are bringing the ballot box to Tumu to count, you will know your standing. Candidates winning, no. One, the winning candidate will not storm a coalition center. He's already ahead. And he knows that he's ahead because he has got certified pink sheets to show him that he's ahead. If you're ahead, why will you storm a coalition center? He's losing candidates who will storm coalition centers. Because by the time that the evidence comes to a coalition center, he already has the result shows that he's losing. And that's when you go and you destroy the place. My point is that Pandai is trying to become a test case, a case study of rewarding bad behavior, of rewarding hooliganism. If we let Pandai stand, it will set a standard whereby anybody losing will just ask, will game the system. I'm losing. What do I do? Let get my supporters. Let's storm the coalition center. Destroy everything there. They force the issue to go to court. Because I always believe that when you go to court, it's a coin toss. Everybody's going to go for a very good lawyer. I go for Martin, you go for Kofi. And then they go. And then we've tossed the coin. And if I'm lucky, my political party will help me get a good lawyer, pay the lawyer fees. I just sit down. And before I realize, eternal election day I lost 2, 3, 4 months and I've won. We shouldn't let Pandai define that. We shouldn't be defined by that. There are different reasons. In the case of the question, it wasn't violence that led us there. There are legal, constitutional things that nothing could have prevented us. But in this case, we know what led us there. We shouldn't let Pandai stand and become the yardstick. That is 1 to 2. Also, there's something that I think there are a lot of lawyers different. Why is it that judges will say, this is my ruling, but then give me another month, 2 months, 3, 4 months to bring out the actual decision? Why? Why did they do that? I don't know why. Like, I'm not saying this particular judge. My point is that, look, when they do that, they unnecessarily raise the pressure and the ante. And then in that follow period, the period from the ruling to when the actual thing actually comes out, it now opens everything to what? Conspiracy theories, of manipulations, and of everything. You are the judge. The cases have ended today. Today, everybody has filed their closing statements. Why can't you say, okay, I'll give you the ruling this time, a time sufficient enough for you to be able to come out with your reasoned decisions and release everything? Why do you have to do that? I mean, that part, especially in this part of the country, it becomes very powerful. People are not saying, oh, is this conspiracies? Until the ruling comes out. There was one instance where a ruling came out and shut everything. I think it was the case of the Daddy Lumba descent, when the woman came out with the judgment to shut everything. My point is that, can we go to a system whereby judges should, I mean, they determine the time, determine that, okay, for this particular case, I need this amount of time to come up with my full judgment and release everything once. Okay. When you do that, you dial down the pressure, you dial down the tension, and you make it easier for everybody to move on, so that the people, I think mostly people wait for the actual ruling to appeal, right? So if I don't have the actual ruling, what am I going to appeal for? How am I going to appeal? I'm not saying but I'm saying that if I want to appeal, sometimes it would be better to know that these are actually the reasons why you're appealing, so that I don't appeal and then something comes out that I don't know of. Basically, you can add, but again, I'm saying at the end of the day, it should be possible for the judiciary themselves to say that, it should be possible for the judiciary themselves to say that, let's not create room for conjectures. Let's not create room for guesswork. Let's not create room for conspiracies. Come with your ruling and the reason behind it once, and do the bet. Whatever we do, whether it is a security problem, whether it is a logistical problem, whether it is a legal problem, we need the same way that we have been able to drastically reduce, if not render, the snatching of ballot boxes. We need to be able to fortify coalition centers. We need to be able to say that if this is a coalition center and you are not allowed to be there, don't be there. We need to be able to make sure that you cannot storm a coalition center to disrupt it, because almost all the cases that you've mentioned have to do with some form of storming coalition centers. If we glorify Pandai, if we let Pandai become the case study, if we let the Pandai become the case study, it is going to unleash some amount of violence at polling centers that will threaten the life of electoral workers, political observers, and everybody, and it will render our elections not credible. So please, whatever we need to do, we have to. If not, we are just dealing with the cosmetic things about each issue, but the real issue is that the violence in Pandai begets the violence in Parliament, and violence always beget violence. Thank you.
No.
It's not. Today you spoke more than everybody.
Hold on.
You spoke more than everybody.
Wait, please. I'll give you because this directly falls on your lap as a chief whip, so you have the last word on this. But on this Pandai situation and whether or not the clerk notifying Parliament at the time he did falls foul of the law at any point, or slipping into the realms of contempt? Counsel.
Hey, for contempt, that would be far.
That was the reference that Justice Abdullah was making.
No. I don't see how contempt comes in unless maybe didn't make. There's a what do you call it? A judgment of a court. The clerk reads the judgment. He thinks that based upon it, he should issue his letter to the EC, and then Justice Abdullah, he said that can be contempt.
No, that's what I said.
I
said that the EC acting when.
That's what I was. But just 2 minutes on this. Quickly.
Yes,
2 minutes.
Let's avert our minds to Article 1125 of the Constitution. It says, whenever a vacancy occurs in Parliament, the clerk to Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and a by-election shall be held within 30 days after the vacancy occurred. Now, on the 27th day of November, I raised the matter in Parliament, and Speaker had cause to come pronounce on my position. And he said, the order emanating from the High Court Commercial Division, Tamale, is to the effect that ex nihilo nihilo fits. You can't put something on nothing and expect it to stand. The pronouncement that brought Nyindam to Parliament, for purposes of which he was sworn in, to serve as the elected representative for the people of Mandai, had been declared null and void, and a rerun ordered. So he was no longer a member of Parliament. But he was saved by the rules of the Court of Appeal rules, automatic stay of 7 days.
Okay.
But upon the fruition of time for up to 1st December, it will no longer, my position will be tenable. So at the time I was raising the matter, I was premature.
Okay.
So Parliament acted upon that decision by Speaker. Automaticity of law.
Thank you.
So that's about it. But let me say this. What Zaato said about the NDC is absolutely incorrect.
Okay.
We were a participant in that election. On the day of the collation, that was the collation center. And our candidate came there in his car. When the violence erupted, they had to come and evacuate people. Right. You have to show the video. Show the video.
I'll also give you the video.
So to say, look, it's the NPP that created the chaos.
All right.
Why were the ballot boxes taken to a place and Nyindam declared? You think that when Nyindam was declared, and we went to court, we couldn't have brought an injunctive order to stop him, but we allowed him to hold office. In Jatikwesi, he was not allowed. So when we made this argument, we needed to be very clear as to the entity that has suffered the greater damage. Now, in CI 127, clear provisions exist. That, for instance, in Regulation 36, if you interrupt the polls, it's an offense. The people who came there to interrupt the polls because we were leading, they have not been prosecuted. In Regulation 39, declaration of results are done at the polling stations, 152 polling stations. But we're not leading. Why were 41 polling stations destroyed so that Nyindam could lead?
Thank you very much.
So now the court says, in pursuance of Regulation 43 of CI 1,
there's going
CI
to be
43,
a rerun.
to CI 127, let us go and do a rerun. And you say that the results declared null and void or invalid by the court of law should stand.
Thank
it
you.
Can't be.
There's a matter that still concerns you. That is going to be our next issue. But quite a number of your messages coming through right now. This here says that Dafeamekpor doesn't joke with these constitutional instruments. He's an expert in that. You say thank you very much. This one here says that I have enjoyed the diversity in opinions expressed, says especially by Kofi Bentil on the specific pronouncement of the court about elections being won and lost at the polling station. Says that was an expert analysis. He says, can this be played back? And no, we're live on Facebook and YouTube, so you can always play it back. But as you do know, after the show, we put out short videos, and so you'll definitely hear that as well. Thank you. This one, this is coming from Hayford. Thank you very much. This one here says that Ni Odate Mills. Thank you very much for the message this morning. It says that he's referring to Lawyer Martin Peeble's backing vocalist. I don't know what that really means. Thank you for your message this morning. This one also here from Musa Batwa says that thanks to Honorable Dafeamekpor for the legal education. The MPP have no moral justification to condemn the Speaker's pronouncement on vacant seats, you say. Thank you very much for your message this morning. This one here is from Dr. Kofi Asante says, good morning. I agree with Kofi Bentil about the question of standard. Is this going to be the standard going forward? And what do our laws say when such matters happen? I think that it is important that clarity is brought to bear on this. Thank you very much for your message this morning. This one here says that I beg to differ with Kofi Bentil's points. Perhaps controversial elections would attract Kofi's assertion. Until elections become controversial, elections are won at the polling station, you say. Thank you. These are different in opinion, and I thank you very much for. And Dr. Arthur Kennedy, good morning. Thank you very much for your message this morning. And in fact, he's drawing my attention to the OSP matter, which is going to be our next issue. So, Dr. Arthur Kennedy, thank you for your message. I'm going to read that before we get over. Quick one.
Let's be clear about this. One, on the issue of whether an application to a court injuncts action, there have been rulings on both sides. I'm saying this because I think the lawyers have confused the public. There are rulings to the effect that if we are disputing this water, I want to drink it, you say I shouldn't drink it. Once I file a process, nobody will drink it until the court decides. The Park Plus matter also, they've ruled to the extent that, especially when it comes to public offices, etc. So let this go in to the public. There are rulings on both sides, and that's the nature of law.
Okay.
It depends on the fact. That is one. Number two, we have said over and over and over again that we need special elections adjudications courts. This is the reason why. Now, they hopefully can adjudicate these things quickly and seal it. Number three, and I think that most important, because the matters fall left and they fall right, depending on who is dealing with it, it is time for Parliament to agree a standard and work it out somehow into some LI or law or something, so we know that what will happen to an NDC candidate will happen to an MPP candidate, regardless of who is president or who is not. Because this will happen again. And I won't be surprised if next time tables turn, the same people making the arguments today will change and make different arguments. It's not good for our democracy.
Okay.
And when it leads to the kinds of things you saw in Parliament, I worry about a degeneration. And then tomorrow you have something that we all regret.
Thank you very much. And thank you, the many of you who are...
PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.